court ruled that Leon-Issa must give investigators access to her phone by providing the password. Hi again and welcome. This is Links 007 TV News Report, and we'll be right back with the full and exclusive details. Welcome to Links 007 TV News Report, providing you with the best in local and international news updates. This is a place where you can get the most reliable and informative news information. Links 007 TV News Report. Welcome back and thanks for joining us. This is Links 007 TV News Report. The court has ruled that Leon-Issa must give police access to her cell phone by 4 p.m. Friday, September 29. Leon-Issa fought for a little more than a year to prevent access to her cellular phone, but in the end, the court has ruled that she will have to allow police investigators to enter her phone by 4 p.m. on Friday in relation to the brutal murder of her son. The development follows this morning ruling by the Supreme Court that she does so. The police had argued that they needed access to the device in order to advance their probe into the murder of 9-year-old Gabriel King. By their ruling, 3-judge panel dismissed a claim brought by Leon-Issa seeking to squash a production order in relation to her phone on the basis that the search by the police would breach her privacy rights. The court pushed back on an argument stating that the benefits to gain from gaining access to the production order far outweigh the breach of her privacy claim. King, an autistic child, was brutally murdered in St. James on January 13 last year. The child was reportedly abducted from his mother along the Tuckermain Road and later found dead in his mother's vehicle, which was abandoned off the Fairfield Main Road in Montego Bay. Leon-Issa told investigators that she was attempting to navigate a pothole when armed thugs hijacked her vehicle and sped off with her son. The case had stalled because she had refused to allow investigators to search her phone. The St. James Parish Court previously ruled that Leon-Issa must provide her password and that she is not allowed to be present while her phone is being analyzed by experts. However, her attorney and technology expert may observe the process. On September 6, 2022, the court ordered that Leon-Issa to allow investigators to access her phone within 48 hours, but she failed to comply. After the deadline, the police returned to the court and the judge issued a new 6-day deadline. That was also not complied with. There was a major development in March when the Supreme Court granted a stay of order to search Leon-Issa's phone following an application by her attorney. The attorney requested the stay as they await the outcome of a constitutional motion filed on the behalf of Leon-Issa challenging the order to search her phone. Her attorney argued that the order to search Leon-Issa's phone is a breach of her rights and privacy, the lawyer stated. We will now provide you with some proceedings of what took place in court earlier today.
Cameron, go ahead. Yes, Mr. Cameron, you were 20 minutes late for court, yeah? Very well. Just announce the appearance, Cameron.
My ladies, I'm Chuka Emeka Cameron, instructed by Carolyn Reed and Company, and I appear on behalf of Mr. Matthew Gabidon, who appears alongside Kamau Roddock, appears on behalf of the defendants here.
You are instructed by whom again? Repeat.
Carolyn Reed Cameron, or of counsel.
Sure. Who you were instructed by. Right. Because we had that you appeared for the claimant, not instructed
Indeed,
by.
that is correct. That is correct. Thank you. Thank you very much.
And Mr. Gabidon is here for the Director of State Proceedings.
That is so, my lady.
All right.
I must apologize, Roddock's absence today.
Thank you. All right. So this is the decision in the case of Amoy Leon-Issa, who is the claimant, Detective Constable Julian Fraser, the first defendant, the Commissioner of Police, second defendant, Her Honor Mrs. Sasha Marie Ashley, the third defendant, and the Attorney General of Jamaica, who is the fourth defendant. This matter was heard on the 14th of July, 2023, and we're delivering the judgment today, which is the 29th September 2023. Now, as an introduction and background, there is a written decision. We are not going to go through the entire judgment. It is 46 pages long, so we certainly are not going to go through the entire judgment. We will be summarizing aspects of it, and we just highlight certain areas that we think are important to highlight at this time. In relation to introduction and background of this judgment, the claimant, Mrs. Amoy Leon-Issa, filed a constitutional claim seeking declarations among other reliefs under Section 19 of the Constitution of Jamaica. Now, the subject of this claim surrounds a production order granted by the third defendant, Her Honor Ms. Sasha Marie Ashley, which she alleges breaches her constitutional right to privacy. Now, the first offender, Detective Constable Julian Fraser, made an ex parte application for the grant of a production order in respect of the key to an iPhone, the property of the claimant, for the purpose of an investigation into the death of GK. We are only giving the initials of the deceased as due to his age. So into the investigation into the death of GK, son of the said Mrs. Leon-Issa. The murder of GK occurred on Thursday, January 13th, 2022, about 11:30 a.m. between Oak Hill Avenue and Fairfield Avenue, Fairfield Estate in the parish of St. James. Now, on Tuesday, September 6, 2022, the production order was granted by Her Honor Mrs. Sasha Marie Ashley in the St. James Parish Court, and we in fact detail what the original production order, the contents of the original production order. Now, the production order granted was upon an ex parte application of Detective Constable Julian Fraser. On the 4th November 2022, a notice of application for court orders was filed at the St. James Parish Court by Caroline C. Reed and Company, attorneys at law on behalf of the claimant, seeking a discharge or, in the alternative, a variation of the production order and an extension of time within which to comply with the order. The application was heard between January 14th and 18th, 2020. Was heard between November 14th and 18th, 2020. Her Honor Mrs. Ashley refused the claimant's application to discharge the production order, but varied the original order by deleting any mention of cell site in the order. The learned parish court judge also added some ancillary claims to the production order, and we then detailed in our judgment the amended production order. Now, the claimant also filed an application for disclosure of all documents related to the request for the production order. That application was heard by the parish court judge and refused. On the 16th of December 2022, the claimant filed a fixed date claim form before this court challenging the production order. The claim is for constitutional redress under Section 19 of the Constitution, that the provisions of Section 13 of Chapter 3 entitled Charter of Fundamental Rights and Freedoms have been and are being breached. Now, the claimant sought a number of declarations in his application. He also sought a number of reliefs in relation to this production order, including an order quashing the orders granted by the learned parish court judge, vindicatory damages, any further and such other relief as the Honorable Court deems fit, and cost in the claim. Now, what we had done is we went through the claimant's submission in relation to the application, and we made note of the cases that Mr. Cameron had utilized. Mr. Cameron also submitted in relation to whether or not there was less intrusive methods that could have been utilized by the police under the Interception of Communication Act as opposed to the Cybercrimes Act. We had gone through and summarized his submissions in relation to that, and Mr. Cameron submitted as to fair hearing, right to fair hearing, that the claimant had not, in fact, received a fair hearing, and he also pointed to the disclosure that had not been made concerning the ex parte application before the learned parish court judge. We summarized also the defendant's submission in relation to this claim, and the defendant's submission was that there was no breach of the right to privacy of the claimant. They, in fact, indicated that Section 21 of the Cybercrimes Act had in it safeguards, and the safeguards, in fact, the built-in safeguards or the safeguards in the orders itself was of such that even if her right to privacy had been breached, that it was proportional. Now, we dealt with the issues in relation to the case, and we found that the issues raised in this case were whether the production order issued pursuant to Section 21 of the Cybercrimes Act breached the claimant's right to privacy? 2, if there was a breach, was it proportionate? 3, were there any orders that could have been made by the learned parish court judge that would have been less intrusive? And 4, were the orders made in the production order too wide and so breached the claimant's right to privacy? We then went through a discussion as to the scope of the right to privacy. We had dealt with a number of cases, both local cases, Canadian cases, Privy Council cases that have dealt with the right to privacy. So we had a full discussion in relation to the cases that were submitted, and some that came up through the course of research. Some of the cases that were dealt with in this decision were the Jamaica Bar Association and the Attorney General and the General Legal Counsel, the Queen and Oaks, the case of Julian Robinson, and the case of Ferron. We also dealt with Sheldon, Canefield, and the Queen. So we dealt with a number of cases in relation to the law. Now, going to the first issue was whether the production order issued pursuant to Section 21 of the Cybercrimes Act breached the claimant's right to privacy guaranteed under Section 13(3)(J)(3) of the Charter of Fundamental Rights and Freedom. Now, we looked at the actual Section 21 of the Cybercrimes Act. We looked at the Charter of Fundamental Rights and Freedoms at Section 13(2) of the Constitution. We looked at the various cases, including the Jampar case, the Canefield case, and we found that the fact of the circumstances of how the phone was retrieved is part of the totality of circumstances that must be considered. And in this particular instance, the discussion of those circumstances may be more appropriate when considering whether the reasonable expectation of privacy in the subject matter of the search may be outweighed by the contravening interests. In other words, whether limiting the claimant's right to privacy is demonstrably justified. And we went on to discuss the case of Oaks. So on the first issue, we went through to see whether or not the claimant had a right to privacy, and we came down to we have to look at the discussion in the case of Queen and Oaks to see whether or not it is proportional. We then went to the test of proportionality as set out in the case of Oaks. We went through the various cases. We went through a number of human rights cases as well, and we found at paragraph 81 that Section 21 of the Cybercrimes Act contains the necessary safeguards sufficient to limit as much as possible the harm or risk to enjoyment of the right to privacy, and is therefore proportionate to the state's aim of improving investigative measures for the detention and investigation of serious crimes in a digitally and technologically advanced society, and therefore demonstrably justified in the circumstance. We in fact submissions were made as to whether or not the requisite protection had been in place, and Council had submitted to us concerning the Data Protection Act, and we had gone through the different statutes, and we found that in assessing whether the varied production order satisfied the test of proportionality, a careful assessment of the actual wording of the order is necessary. It is noted that the wording of the varied production order is much more restrictive than that which was proposed by counsel for the claimant, and it stated the purpose for which the data was being extracted. Incidental to the process of extraction was the necessity to interface with information in the claimant's phone which was irrelevant to the investigation. The data to be extracted would have to be limited to the purpose stated in the order. The circumstances under which the iPhone came in the possession of the police is also of great importance. The iPhone was retrieved from the vehicle that GK's body was recovered from. Claimant stated in her affidavit that she had given the iPhone to GK to keep him occupied whilst he was in the vehicle. Based on these facts, it is understandable and reasonable that the investigators would wish to view and possibly utilize the contents of the iPhone to assist them in their investigation. So we had found that we find on an assessment of the evidence before, an assessment of the evidence, the objective of the investigating officer is investigation concerning the death of GK. The iPhone may be useful in the investigation, and as such, the request to retrieve potential relevant data cannot be considered arbitrary, and that the relevant data would be rationally connected to the investigation. The next issue was Were there other orders that could have been made by the learned parish court judge that would have been less intrusive? Mr. Cameron had suggested that we are possible that the Interception of Communication Act may have been would have been less intrusive, I should say, rather than the Cybercrime Act. We looked at both the Cybercrime Act and the Interception of Communication Act, and we also went on to look at the Data Protection Act, and we found that the order made was not overarching, and based on the evidence, we conclude that it would be proportional to make an order that the key to access the iPhone be produced. The final issue was whether there should have been disclosure of the application and the affidavit in support that was filed and placed before the learned judge of the parish court. We looked at a number of cases concerning disclosure. We looked at the local case we looked at the Privy Council case of Dawn Satterwhite. We looked at the Canadian case of the Queen and Gills. We also looked at the case of Altec Limited, and at the end we concluded that it is our considered view that in the case at bar, the circumstances provide and permit the tribunal to impose limitations on the right of the claimant in furtherance of a legitimate aim. We find that there was no breach of the claimant's right to a fair hearing pursuant to Section 16.2 of the Charter of Fundamental Rights and Freedom. So in conclusion, we find that although there would be a breach of the claimant's right to privacy, it was proportional in a free and democratic society. The court finds that the request for the key to access the data on the iPhone would be limited to investigations into the death of GK which occurred on the 13th of January 2022. It is our considered conclusion and finding that the benefit gained from granting the amended production order that would aid in the investigation into the death of GK far outweigh the breach of the privacy of the claimant. So the orders that were made is that the claimant is not entitled to any of the declarations sought in the fixed date claim form. 2, an order quashing the orders granted by the learned parish court judge Sasha Marie Ashley on the 6th of September 2022 and the 18th of November 2022 is refused. Now, the court does not find that the amended production order granted on the 18th of November 2022 to be unconstitutional, void, and of no legal effect. Now, an order for vindicated damages on the footing that the actions of the first, second, and third defendant amounts to a breach of the constitutional rights granted to the claimant by the Charter of Fundamental Rights and Freedoms and the Cybercrime Act is refused. Claimant is to produce the key to the iPhone as per the varied production order made by Her Honor, Mrs. Sasha Marie Ashley, on the 18th of November by 4 p.m. today, the 29th September 2020, and there is no order as to cost. Mr. Cameron, we are not minded to grant leave in relation and we are not minded to grant a stay in relation to this order. All right, the judgment will be emailed to you. Thank you.
This has been Links 007 TV News Report. Thanks for watching, and I will continue to track this story and provide you with the latest information that comes in a later newscast.